So this is going to be a big divergence from the normal sort of topics that I cover on this channel. Today I'm going to talk about gun politics and the upcoming Supreme Court case, New York State Rifle and Pistol Association versus Bruen. If you were expecting any philosophy of religion here, I'm afraid you're going to have to move on. If you want to hear about gun control arguments that are so bad they rival the sort of drivel you'd hear from a young earth creationist or an anti-evolution apologist, then strap in. In fact, I'd appreciate it if you let me know how you feel about non-philosophy of religion videos on my channel in the comments section. Now, if you hadn't been able to guess from my normal videos or my Twitter feed, I'm pretty liberal, but actual people don't really line up well with their parties perfectly. I'm a pro-gun liberal who largely votes Democrat because on the total balance of issues, they suit my priorities best. This is just like a conservative who would support increased taxes on the rich and corporations, but votes for Republicans because of culture issues. However, the issue has become a lot more acute for me in the last year and a half when I actually became a gun owner because of the pandemic, and I've become more interested in Second Amendment politics as a result. Now, the issue affects me directly because I live in New Jersey, one of the most anti-gun states in the nation. This means, much like 7 other states, including New York, I am de facto banned from getting a concealed carry permit. This is because these states are may issue, where they can subjectively deny any permit application if the official feels that the person applying does not have a quote-unquote good cause or justifiable need for self-defense. In practice, this means no issue to about 99% of the population, but I'll get into that a bit later. Now, this is in contrast to the 42 other states that either allow someone to carry concealed without a permit of any kind, or shall issue states, where once a person has completed whatever requirements the state puts out, typically a training class and or live fire exercises, the state must issue the carry permit. The Bruen case is going to be heard by the Supreme Court on November 3rd, and the case is challenging the exact good cause requirement to be issued a carry permit in New York City. An incredible amount of amicus briefs have been filed by both sides. These are basically arguments sent to the justices where various groups or organizations or states give their support for one side or the other. What I want to focus on was the brief urging the court to uphold New York's restrictive laws, and this was filed by over 150 senators and House members, because one would think that they would sign on to only the brief with good arguments. What I found was simply an embarrassing set of arguments that dance around the issue rather than address it directly while trying to avoid facts they'd rather not discuss. I'll put a link to the brief in the description box so you can follow along and verify what I'm saying is accurate. With that said, let's tackle their first mistake. On page 19 of the document, or 37 of the PDF, we get to this gem. I quote, "Unrestricted concealed carry can harm First Amendment rights. Civilians carrying guns into communal spaces can chill or shut down the rightful expression of free speech and political protest that the First Amendment is intended to protect. Requiring licenses to carry concealed guns in public and imposing reasonable conditions on licensure is an important and effective tool for preventing these civic harms. The inability to regulate concealed firearms in public would put legislatures at a severe disadvantage in their mandate to protect the public sphere on which the constitutional democracy depends." End quote. The section then goes on to describe a peaceful protest for racial justice in the summer of 2020 in Omak, Washington. The protesters ran into an unauthorized and armed militia group facing them, with others on nearby rooftops that the protesters felt were ready to act as snipers. They argue that this causes a chilling effect on the protesters. Now, on its face, this doesn't immediately sound like a blunder, right? I don't intend to debate laws permitting the open carry of firearms, specifically in this case rifles. In fact, I can completely grant every single premise here, and it has absolutely zero bearing on the case at hand. This is because the arguments in the Bruen case that they're making are about the good cause clause for getting a New York City permit to carry a concealed handgun. The state will still be regulating who can carry. Nothing in the case is requesting that New York must amend its laws to permit the open carrying of rifle or long guns. It doesn't even challenge the notion that people have to apply for a permit. It merely challenges the portion of the law that New York and other states use to deny permits to otherwise law-abiding citizens who could demonstrate that they can safely handle a handgun. Now, if you have a concealed carry permit and you pull out your weapon, that's known as brandishing, which is itself a crime unless the concealed carry holder has what the law says is a reasonable fear for their life or the life of a third party. And for reference, a jury is who decides what fears are reasonable or not in any individual case. So if the Supreme Court were to strike down the law, then all it means is that New York and the 7 other states will have to become shall issue for concealed carry permits only, not permitless carry, or not permit the carry of long guns of any kind. They will still only allow carry by license. It doesn't mean that protesters will face an unauthorized militia. The entire case is about whether a good cause is a reasonable restriction on the issuance of licenses, and this argument simply doesn't address that. It's just talking about people being intimidated by open carry of rifles, which wouldn't be permitted under the decision of striking down this law. Now, there is another reason we should reject this argument, and that's because 42 out of 50 states are either shall issue or permitless carry states, constituting roughly 75% of the U.S. population. It is simply absurd to say that 75% of the country cannot exercise their free speech and assembly rights because those states allow for specifically the concealed carry of handguns. If anything, it is an argument against open carry of handguns and or long guns. That's it. Now, the second terrible argument they make is very similar to the first one. It's on page 21 or 38 in the PDF. To begin, quote, "The presence of unlicensed firearms in public can also threaten free and fair elections, culminating in smooth transitions of power. Last year, a number of states saw their efforts to count ballots and certify the election delayed and inhibited by firearms in the public sphere." They then go on to describe 2 individuals in Philadelphia who were carrying rifles outside an area where the votes from the 2020 elections were being counted, creating a hostile and fearful environment for the election officials. Now, I certainly agree that such a display will cause that effect, and I also don't support any efforts to intimidate election officials counting votes in an area known to heavily favor one party. Again, this is an instance where all of the comments from the previous section about the case not being about the open carry of rifles here, so this basically invalidates the argument off the bat. It also doesn't challenge laws banning carry in polling places or other government buildings like courthouses, which still exist in shall-issue states. However, what's actually hilarious is that they even admit in the brief that the people carrying the rifles in the examples cited were arrested because they didn't have permits to carry the weapons. The next hilariously bad argument is on page 23 or 40 in the PDF, referencing the January 6th insurrection. To quote, "While most participants in the January 6th insurrection came to Washington, D.C. from other states and appeared to comply with the district's laws prohibiting gun possession and public carry by out-of-state visitors, some insurrectionists illegally brought firearms to the district and inside the Capitol in an attempt to thwart the democratic process." End quote. Now, this argument really takes the cake for me in terms of being so bad that they might as well be arguing for the opposite side, urging the justices to strike down the good cause requirement. Now, let me state the obvious. I found the insurrection abhorrent, and I hope people who try to usurp our democratic process are prosecuted to the full extent of the law. I was a Biden voter in 2020, despite the fact that he's terrible for the Second Amendment. On the whole, of other issues, I found him to be the best candidate. That said, the point is that the insurrectionists who brought weapons to D.C. were doing so illegally, as admitted by the argument. The point has nothing to do with the case's objective of striking down the good cause section of New York's concealed carry permit law. However, even more devastating is the fact that Washington, D.C. has been a shall-issue jurisdiction since 2017's Wren v. District of Columbia. In fact, if New York State Rifle and Pistol Association wins the case, all that would happen is that the courts will force the 8 may-issue states to adopt the kind of carry laws that are in Washington, D.C. The fact that literal insurrectionists, people trying to overthrow the U.S. government carrying out the democratic process of a free and fair election, followed the still restrictive D.C. carry laws, not bringing their guns because they didn't have D.C. carry permits, is evidence that there is no real risk to New York City or the other states if they are forced to adopt the exact same shall-issue system that D.C. now uses. Next, I want to show where the legal arguments in favor of upholding the good cause laws not only fail, but are actually being argued in bad faith. A lot of the argument hinges on the idea that good cause may-issue laws have been upheld by various U.S. District Court of Appeals, surviving what is called intermediate scrutiny. To avoid a lot of details here, there are 13 different district courts of appeals covering various regions of the country. Intermediate scrutiny refers to the sort of test the courts use to determine the constitutionality of a law. There's basically 3 levels, low, medium, and high, and as the name implies, intermediate scrutiny would be the medium sort of test. The legal argument that is being put forward here is that the courts have determined that Second Amendment laws should use intermediate scrutiny standard, and when the district courts have used that standard, the may issue laws have passed the test in all circuit court decisions that have considered it. And this is where things get misleading. First is the fact that district courts tend to mirror the regions they cover, so the circuits in the swaths of the country that have shall issue or permitless carry laws don't really hear challenges to may issue laws because there aren't any in those regions, and even if they did, they are staffed largely by conservative justices. Conversely, the circuits where the may issue laws where they tend to end up being challenged, those judges are pro-gun control, very liberal, and they've upheld these laws. Except not always. Now, if you know about Illinois, you know it is a heavily blue state that wants a lot of gun control. Except, oddly, it's shall issue. This is because the 7th Circuit U.S. Court of Appeals ruled in Moore v. Madigan in 2013 that Illinois' no-issue permit system was unconstitutional, and the decision heavily implied they needed to adopt a shall-issue system. The court gave 180 days for the legislature to draft such a law, or they would strike down the existing system, and if they did that immediately, there would be no carry laws, and there would basically be unrestricted carry in Chicago and all of Illinois, so they gave them a grace period. Now, the governor wanted to challenge the case to the Supreme Court, but the Democratic legislature didn't want to take the risk and overrode his veto of the new shall-issue law. As such, the governor's appeal was moot, and the court's decision isn't counted against may-issue laws. Now, similarly, we have heavily blue and pro-gun control Washington, D.C., and they had exactly the sort of good cause may-issue laws that the 8 states in question have, and it was struck down by the U.S. Court of Appeals for the District of Columbia in Wren v. District of Columbia in 2017. As stated, Washington, D.C. is now a shall-issue jurisdiction, exactly what the plaintiffs in Bruen want. However, since that court is not technically in the circuit courts because D.C. is not a state, that decision is not counted by the pro-gun control arguments. Now, here's where we can prove that the 8 states and gun control organizations are actually arguing in bad faith, because D.C. wanted to appeal Wren to the Supreme Court. However, the deliberations played out far more publicly than they did in Illinois. The 8 may-issue states' governors and attorney generals at the time, as well as national gun control organizations, publicly and privately urged D.C. officials to avoid appealing to the Supreme Court because they feared it would strike down all may-issue laws back in 2017. In fact, when announcing their decision not to appeal, the D.C. officials stated exactly this concern, having had the Supreme Court Heller decision in 2008 overturn D.C.'s ban on handguns and establish an individual right to own a handgun. The point of all of this is not that the courts of appeals have all agreed that may-issue laws will survive intermediate scrutiny. Furthermore, there has been a concerted effort by the 8 may-issue states to avoid having this issue come before the Supreme Court because they're afraid the laws will be struck down. Now, the strongest argument that good cause may-issue laws are unconstitutional is not actually in the details of conflicting decisions of the different U.S. courts of appeals. It's because such laws violate basic notions of fairness and equality of rights under the law. It's definitely a case of rules for thee, but not for me. Now, there are 2 classes of people that universally get granted concealed carry permits under the sort of good cause may-issue laws: the rich and famous and retired police officers. In some states, there's an ongoing problem of a 3rd class, those just wealthy enough to bribe local officials. There's a famous case in California of an Apple executive sending a literal pallet of iPads to the police precinct that would approve his concealed carry permit, as well as other cases in New York and other states where police officers have taken bribes to issue carry permits and have since gone to jail. However, not all bribes in the U.S. are illegal, as our campaign contribution system lays painfully self-evident. Do you want to know who had a New York City concealed carry permit decades ago, back when they were a Democrat, donating millions of dollars to Democratic gun control candidates locally and nationally? There's a real estate developer named Donald Trump and his 2 sons, Eric and Don Jr. That's right, them and various other wealthy New York City residents get their carry permits too. But sometimes straight campaign contributions aren't even necessary, and sheer fame can get someone through, like Howard Stern. Although it is sort of unclear if it was fame and campaign contributions, we don't really know. All we know is that he does have a permit. Now that said, there's this final class that gets their carry permits, the retired police officers. Most of the time, the government has to use them as the deciding authority on whether to deny or grant permits. And in order to make sure they don't get too permissive in what counts as a good reason to have a carry permit, realizing that they'll want one when they retire, so they've written the laws such that retired police officers are granted their carry permits, often getting to waive hundreds of dollars in application fees in New York City specifically. This extends to district attorneys, local judges, and their friends or family. But what about normal citizens like you and me? Well, by statute, a simple desire for self-defense is insufficient as a good reason for a carry permit. What's worse is that normal citizens not rich or politically connected enough are regularly denied even if they've been repeated victims of violent crimes. In one case in New York, the police denied a person their carry permit despite them applying after being robbed at gunpoint in their neighborhood. By the time the application was processed, it had been 3.5 years since the robbery, and the police concluded that the individual was no longer in extraordinarily personal danger. I guess maybe if he was a victim of armed robbery more recently, they would have granted his permit? I doubt it. The fact of the matter is that normal law-abiding citizens have no chance of being granted a carry permit. In fact, pro-gun control briefs have this as the basis for their argument, and it is effectively that no one is granted carry permits under the may issue laws, and so that those places are safer. What's more is that the plaintiffs in the Bruen case are only arguing that these last 8 states, with only 25% of the U.S. population, just have to become shall-issue states. As we've seen in the anti-gun jurisdictions forced by court order to become shall-issue, like Illinois and Washington, D.C. specifically, they still impose extraordinary hurdles to getting their carry permits in an effort to dissuade citizens from carrying. Both places require 2-day training courses as opposed to a single-day class, which is normally what's required if you go to get a permit in a shall-issue state. There's a variety of fees, a very long waiting period, etc. But at least you can still get one eventually when you jump through all the hoops. And that's really all this case is going to get gun owners in these 8 states. Still, gun control advocates want to create an aura of unjustified fear if the Supreme Court gives gun owners their rights back. I've covered why these arguments are bad, but additionally, there is the wealth of data available that show that concealed carry permit holders are among the most law-abiding populations in the country. I've given a link in the description box to this study. Now, this doesn't stop them from being unfairly used as scapegoats, like in 2005 when Philadelphia was experiencing a surge in gun homicides. Then Mayor John Street blamed the increase in murders on the fact that the city residents can actually get concealed carry permits because of Pennsylvania law. He actually wanted to stop issuing carry permits in the city because of the increase in murders. The problem for Mayor Street was that exactly 0 of any of the murders in the city were committed by citizens who had a concealed carry permit. This shouldn't be surprising, since these are the people who have gone through the process to get government approval to carry a handgun concealed in public, whereas the overwhelming majority of gun homicides and other crimes are committed by people who did not obtain their firearms legally. It's for these reasons that the Supreme Court is likely to overturn these May issue laws, I hope, freeing the last 25% of the country to carry once we jump through the hoops our states put in front of us. It's also the reason that other people do not need to see such a ruling as catastrophic or something that decreases public safety. Thanks for